I'd like to take a minute to talk to you about drunk driving cases in New York. In New York, the legal limit for driving while intoxicated is 0.08% blood alcohol content. If you blow more than a 0.08, you can be arrested and prosecuted for a DWI offense, which is a misdemeanor in New York. If your blood alcohol content is more than a 0.18%, you are charged with what's called an aggravated DWI, which carries additional penalties above and beyond the normal misdemeanor penalties on a DWI case. Further, even if you've never been arrested before and you are driving while intoxicated, 0.08 or more blood alcohol content, and you have a child in the car under 16 years of age, you are automatically charged with a felony offense, which the conviction for which will cause you to lose certain civil rights that most of us take for granted, like the right to vote, serve on a jury, hold a government job. When you are stopped by a police officer for a DWI, you will be initially asked a series of questions that you don't have to answer. Questions like, have you been drinking, and how much have you been drinking? I would recommend being respectful, but not answering those questions, because the answer to those questions will often lead an officer to probable cause to arrest you, even if your admission is, I had a cocktail a couple of hours ago. You don't have to answer those questions, and I recommend that you don't. The officer will also ask you to take a series of field sobriety tests, like walking a line, finger to nose, reciting the alphabet. Again, you don't have to take those tests, but your refusal to take those tests may result in sufficient probable cause for the police officer in and of themselves. If arrested for a DWI offense, you will then be taken by the police to the police station, where you will be asked to take a formal breath test, a breathalyzer test as it is referred to, using equipment like the Intoxilyzer 5000, which is a legally admissible result in court. You may have been asked to take a similar test, a portable breath test on the street. That test is not admissible in court. It can only be used for probable cause purposes. The breathalyzer test at the police station can be used against you in court to determine your level of intoxication and what offense specifically you should be charged with. I should also say that any prior conviction for a DWI will automatically make a subsequent arrest within 10 years a felony offense and subject you to the likelihood of incarceration. Now, I'd like to take a minute and talk to you about whether or not you should take the breath test. You don't have a right to refuse the test. Your refusal can and will be used against you in a court of law. The significance of that refusal is that ultimately, if you go to trial, the evidence of your refusal will be used against you in court. The jury will be instructed that your refusal is consciousness of your guilt, that you only refused to take the test because you knew you would fail it. But you are providing the police and the district attorney with less evidence, direct evidence, to use against you. Because when you take the breathalyzer test, you're producing a legally admissible reading of your blood alcohol content that is considered presumptive evidence of your intoxication if you blow 0.08 or more on that piece of equipment. Many people ask, should I take the test or not? If you refuse, your license will be immediately suspended and subsequently revoked. And if you work and need your license for work, you will not be able to drive at all while your case is pending. And it can take many months for your case to be resolved. If you take the test, you will be eligible for a hardship and a conditional license that will allow you to get to and from work, school, doctor's appointments, those kinds of things while the case is pending. I often tell people, first time arrest, no accident, no aggravating factors, you're probably better off taking the breath test, even though you may be giving additional evidence to be used against you. The district attorney's office is more likely to plea bargain such an offense, and you'll be able to maintain your license and continue to drive while your case is pending. If you have any other questions, feel free to call me at our Long Island office, 516-294-0300.